denial of bail. It's very clear from this judgment that none of those conditions are significantly satisfied so as to deny 147 people bail. So this, in a sense, is really where we are in terms of labor law adjudication. I think that's the important point to make. And if you go back into the details of the incident, the series of developments that took place roughly between June 2000, in fact, the first week of June 2011, and sometime in late 2011, and then, of course, on July 18th and the immediate aftermath, what becomes very clear is that where the labor machinery should have stepped in, it was absent. It was completely absent. And if Karamat is concerned about military law in Pakistan, then I think we should be equally concerned about police law or police rule in this country. What the military possibly does in Pakistan, the police increasingly does in the non-military space in India. So repeatedly at Suzuki, but in the other cases that I mentioned, Regency Ceramics, Pricols, Graziano, the police stepped in repeatedly where the labor machinery should have been present. And I would draw attention to Section 10 of the Industrial Disputes Act, which finds a mirror in every industrial disputes or employment relations or industrial relations legislation subcontinent. I'm only going to read about 10 lines of it, which says, where government is of the opinion that an industrial dispute exists or is apprehended, it goes on to say how government should act. And it sets out very clear mechanisms on which government is to act. And I want to dwell on the word, not just where a dispute exists, but where a government apprehends a dispute. When an employer calls and says, I apprehend a dispute, so send 500 cops to the gate, is that not sufficient apprehension? When an employer is doing it repeatedly month after month, when an employer calls on the weekly off, when the factory is shut, which is what happened in Suzuki, and says we need reinforcement, and the reinforcement that shows up at the factory gate in fact is twice or three times the size of the actual employment shift, or any particular shift, then I think what we learn from that is actually employment relations are no longer being adjudicated under labor law, but they are being conducted under the power of police. And I think if I go back to where I started, that employment relations are not governed by the law of contracts such as property and commercial contracts, because they essentially involve an unequal contract. Then I think it's very clear that if you employ the coercive arm of the state in trying to intervene in what's a labor dispute, then in effect what we're doing, or rather unambiguously what we're doing, is we're actually further squaring the pitch into an even more unequal arrangement where there is the power of the coercive. There's not just the power of the employer in that they employ the workers, but also the fact that they're able to indicate that if we don't succeed, the police will succeed on our behalf. And I think what the Suzuki example tells us, in fact, is if one traces it from 2000 to 2012, then what you have is a story of where actually the employer fails to keep the union out, which they did in March 2012. They technically, or in the strictest sense, or at least as they feel it, they failed to keep the union out. They actually felt pressured enough to accept a union to come to be registered. They were looking for an out somewhere. And I think it's that sort of, where they brought in the police. So where they could not oppress the labor rights of their employees, they actually turned to oppress the civil and criminal rights or citizenship rights of their employees. So I think there I mean, I think if one looks at sort of the question of labor rights in the subcontinent, what comes through in all of these instances, and then of course the non-violent, where there was no actually, I will not say non-violent, but where actually there was no death involved, which is the case of Hyundai, the case of Ford, the case of Toyota, the case of Nokia, and more recently, the suspended industrial action of the workers at Bajaj Auto, the world's first or second largest two-wheeler company. And I'm not just being pejorative when I say first or second. Both the first and the second largest two-wheeler companies in the world are in India. So it's either Hero Motors, which is first, and Bajaj Auto, which is second, or vice versa. Where the employer is very clear that they are not going to A, accept a union, and B, they are not going to negotiate with employees or employee representatives. The managing director of Bajaj Auto said very proudly at a press conference a few days ago that he would not negotiate with the union's representatives even if the strike went on for 500 days. So here was a very clear message coming from a very large employer. His grandfather was considered to be one of the closest friends of, and of course very important financier of Mr. Mohandas Karamchand Gandhi, who's standing up at a press conference saying in the public domain that I will not negotiate, let the law be what it is, I'm not bound to negotiate. And to put this in sort of the context of international law, the rights to freedom of association and the right to collective bargaining are governed by Conventions 87 and 98 respectively. And it's interesting to note that in every country of the subcontinent, major country of the subcontinent, Pakistan, Bangladesh, Nepal, and Sri Lanka, both these conventions have been ratified. India stands tall in, of course, not ratifying them. So on the one hand, we have the kind of sort of abnormality of Pakistan effectively suspending all labor rights for a couple of decades during military law. On the other hand, they actually went on to ratify those two conventions. I think second issue that comes through Maruti and every one of the other experiences, which rarely sort of makes the public domain beyond an immediate point of actually an instance of violence that attracts media attention and obviously sets the class ante up, so to speak, is that every one of these efforts to form unions are accompanied by sort of sustained attacks on individual workers, especially those who are forthcoming in forming the union, taking leadership of the union, becoming office bearers of the union. So that's I think the second thing that's part of the untold story, which is victimizing workers, firing them, suspending them, so on and so forth. A common piece of legislation which takes us back to 1946 that covers standing orders, which is sort of the rules of work in a workplace. In the case of Suzuki, but increasingly in a lot of other places, the employment standing orders are meant to be ratified by a joint union management process where a union exists. Typically, employers get them ratified before a union is formed and try and press them even beyond ratification. In the case of Suzuki, the employee standing orders state unambiguously that workers may be removed from work that is dismissed or fired without notice and without recourse to inquiry. Yeah. Now, this is an interesting thing, that a country that allows trial for murder actually does not allow trial for dismissal from employment. But if you read through the standing orders, it also does two more things. One, which is still quite rare, it actually sort of says that amongst the list of severe forms of indiscipline includes not maintaining personal hygiene. Now, I can't think of anything that's more involving human judgment that's open to interpretation over here. The second, which of course is increasingly being brought in by employers in their new standing orders, something the unions have fought systematically, is actually penalties for industrial action. Penal wage deductions for industrial action. This is something that's come back into the standing orders. I think there are there are two or three sort of sets of, I think, challenges which come to I think, which we need to note when we look at the attack on the right to freedom of association. What employers have used effectively in India and elsewhere in the subcontinent is the sort of opacity of law and the rule book on both the formation of a union and, in fact, the recognition employers are required to accord to unions. I think it's important to think on two legs here. One, to require a compulsory recognition of unions. And even if it's a management union, the fact that an employer has to recognize a union, I think, is something that would, in a way, really help us jump the initial Rubicon of the fact that we cannot form a union. There is a second part. And the second part is, of course, how do we get rid of the employer set-up union? It's not that, I'm willing to accept that as the end of it. The second is that, if there is to be in a democratic society the absolute freedom of choice that employees can have to choose a union of their own, then there can be no way but choosing a union through the secret ballot. And in this case, in this context, the Indian law has over the years sort of shown an emergent sort of openness. It's shown an openness for secret ballot in the case that ended in the Supreme Court on the Indian Railways. It's also shown an openness in the Food Corporation of India. But it continues to show an extremely narrow mind, and this is the Supreme Court downwards, when it comes to the private sector, most notably the recent judgment in Madras Rubber Factory, where it leaves the question of union recognition to physical verification of membership records. Now, as you would all recognize, physical verification of a union's private records are extremely open to all kinds of manipulation, especially if there's an employer behind one of the two unions or one of the more unions. Then there's a higher chance that the employer would be able to not just help in that, but they would also be able to provide resources, which they do all the time. I think the second part, and I'm really going to end over here, the second challenge in union formation is really what capital wants and what we need to fight, and that is the ultimate fight, so to speak, on the ground. Karamat wanted me to speak about garments and wages. I don't think there's that much time. I really think I've overshot. But whether it's garments, or it's automobile, or it's anything in between, what's changed over 20 years, but what's changed sort of systematically over the last century, is the intensity of work. It's changed at a scale that's unparalleled over the last 20 years. And if one looks at these sort of emergent irregular forms of labor, which have really pushed even those in informal employment into conditions of informality, it's the fact that employers are unwilling to accept any form of regulation in the workplace. What they're looking at, from the 7-minute tea time all the way down to the speed of the machine and the manner in which production is organized on the shop floor, going away from the single chain assembly line to multitasking to multitasking Toyotaism, is to control production in an absolute sense. And I think part of sort of union formation, winning workers' rights,